requirements. Madam Speaker, the rule before us today provides for consideration of S-304, the Conscience Protection Act. This bill protects rights of conscience for health care providers who choose not to participate in abortion. The bill reinforces current law and makes clear that federal, state, and local governments, including subsidiary agencies, cannot discriminate against health care providers who choose not to provide abortions. This bill is necessary because the California Department of Managed Health Care has mandated that all health plans must cover elective abortion. This includes health plans offered by religious nonprofits and even churches. This action by the state agency violates a provision of federal law known as the Weldon Amendment, which provides that states receiving federal funds may not discriminate against health plans based on their decision not to cover or pay for abortions. Religious employers in California who offer group health plans to their employees lodged an objection with the U.S. Department of Health and Human Services, which oversees enforcement of the Weldon Amendment. HHS massively and incorrectly reinterpreted the Weldon Amendment to allow California to continue to force these employers to pay for and provide coverage for elective abortions. In addition to providing common sense protections, S-304 also allows a private right of action, giving providers recourse should they face penalties or punishment for exercising their conscience rights. To be clear, this bill does not ban or restrict abortion in any way. If enacted, abortion will remain just as legal as it is today. In spite of this fact, my colleagues on the other side of the aisle will continue to protest this sensible legislation. The Conscience Protection Act is not the only important legislation the House will consider this week. This rule also provides for consideration of a motion to concur with the Senate amendment to the House amendment to S-764 GMO labeling requirements. The Senate amendment establishes a national labeling standard for bioengineered food, with exceptions for foods and products primarily composed of meat, poultry, or eggs. This measure represents a truly bipartisan effort to prevent a complicated patchwork of state laws and regulations for labeling food products sold throughout the country that inevitably would lead to increased prices, confusion, and more than a few frustrated customers. Americans would be well served to have both S-304 and S-764 considered this week, and I commend both bills to my colleagues as deserving of their support, and I reserve the balance of my time.
Gentleman reserves.